considered legislative bodies. There's one exception to that, and that's if it's an ad hoc committee, and we'll talk about that in a little bit. But fundamentally, it's important for you to recognize kind of what a meeting is. So when the Brown Act says that legislative bodies have to conduct their meetings in open, it's important to know what is meant by a meeting. Obviously, a meeting is going to be a gathering of a majority of the members of that legislative body at the same place and same time to hear, discuss, or deliberate upon anything within their subject matter jurisdiction. That's kind of the quintessential what we think of meetings, right? It's important to note that just because a legislative body isn't taking action doesn't mean that it's a meeting. A lot of times, legislative bodies will have a meeting and they'll discuss, they'll deliberate, they'll take input from the public and staff, but they don't actually come to a decision or vote. That's still considered a meeting under the Brown Act. And so we'll talk about what that means. Some exceptions to what an open meeting, obviously individual contacts by a person to the various members of a body. So if you have an applicant and they want to go and meet and talk with each of the individual members of the board or commission, as long as they're not sharing information with the board members about what their fellow board members are thinking or saying, then that individual can go and talk to members of a legislative body and have kind of one-on-one conversations. If you start hearing that person say, you know, your fellow commissioner thinks X or Y, that's when you need to kind of politely stop them and say, thank you very much, but I'm really here just to hear what you have to say and for me to share my thoughts with you. You know, the law doesn't allow me to really take into consideration or really even hear what my fellow boards or commissioners are. Otherwise, there's the potential, and we'll talk about it later, that one person can kind of round up votes, and that's not really what this individual contact exception is meant to cover. There's another exception for conferences and seminars. So sometimes members of a city council or a planning commission or another board or commission will go to the League of California Cities conference, for instance, and they'll hear topics, and they're able to do that. They're able to meet and hear those things. They're able to talk about them as long as they don't start talking about something that's specific within the city of Palm Springs subject matter jurisdiction. Community meetings held by other organizations. So say the Chamber of Commerce holds an event and they want to talk about a particular subject. If it's publicized by that private entity and members of the public are able to attend, then the Brown Act says that members of a legislative body can attend. They can actually participate in that conversation, again, unless it's starting to talk about something specific to your legislative body's subject matter jurisdiction. There's an exception for attending meetings of other legislative bodies. So for instance, if the Arts Commission wants to come and a majority of the commission wants to come and talk to the city council, they can do that. And that's not considered a meeting of that commission. Standing committees. So under the Brown Act, we have a difference between a standing committee and an ad hoc committee. A standing committee is, as the name implies, it exists kind of permanently. It's not meant to exist for a short time period. And it's distinguished by an ad hoc committee, which is created for a limited time period or for a limited purpose. So, you know, maybe the Planning Commission wants to form an ad hoc committee to look at a particular project that's making its way through the process. That is an ad hoc committee as long as it's consists solely of members of that planning commission, not members of the public, not members of staff, and it's less than a majority of that commission, then it's considered an ad hoc committee. What this exception says is that if, say you have a planning commission and you've got a standing committee that was created by the committee or by the commission, and it has 2 members. This exception says that a third or fourth member of the planning commission can attend the meeting of the standing committee, but they can only observe. They can't weigh in. They can't provide their comments. They can just go and listen or view the meeting, and that way it doesn't become a meeting of the entire planning commission. And then finally, there's an exception for social and ceremonial events, so like a ribbon cutting for a project or something like that. If the majority of the legislative body goes to those types of events, that's not considered a meeting that has to be publicized to the public. The key point here is that members of a board or commission shouldn't be talking about matters that are within your subject matter jurisdiction outside of a noticed public meeting. The point is, the meetings need to be noticed by the city, posted online, posted outside the door so that members of the public can see what's going to be discussed and decide whether they want to participate, whether they want to come down to City Hall, or whether they want to log on and participate in the meeting or not. The other component is, once you've posted the agenda, once your board or commission has posted the agenda, you need to stick to that agenda. Again, because the public is relying on the fact that these are the 5 items that you're going to be talking about. You're not going to talk about something that's not on the agenda, and then they're not going to be able to participate. There are some exceptions to that for items that came to the attention of the city after the agenda was posted, if there's like an emergency, an urgent need to take action on it, but that's more of the exception than the rule. Generally, once the agenda is posted, the board or commission has to stick to what's on the agenda. So we've got different types of meetings. We've got regular meetings, special meetings, and emergency meetings. A regular meeting is something that your board or commission has established a regular meeting schedule. You'll do that every year. You'll say, these are the days that we're going to be meeting. Those are your regular meetings. For those meetings, the agenda has to be posted both physically and online at least 72 hours before the meeting itself. For a special meeting, these are meetings that are not set by your board or commission. There's a special need that comes up. In those cases, it is only 24 hours notice that's required. And that's usually done by either the chair of the commission, or if a majority of the commission wants to call a special meeting for a specific purpose, you can do that. And then emergency meetings, this was included in the Brown Act after 9/11. If something urgent, an earthquake or a flood or something happens and there's an urgent need for your legislative body to meet, then less than 24 hours notice can be provided, but the city clerk would need to provide notice to the press and to the public in order to have an emergency meeting. Rarely is that conducted. So again, the concept here is that the public can review the agenda, see what's going to be discussed or acted on, and decide whether they want to come down to City Hall or log in to participate. The participation portion of the Brown Act says that for regular meetings, the agenda needs to provide an opportunity for the public to comment on both the agenda items themselves, as well as any matter within the subject matter of your board or commission. And a lot of times, and it's important to note, this public comment portion is literally that. It's a public comment opportunity. It's not really meant to be an opportunity to engage in discussion. In fact, it really shouldn't turn into a discussion, because whatever the person is speaking on, if it's under the general public comment, then the public isn't going to know that was on the agenda, and so the public wouldn't be able to participate. So at least for non-agendized items, what we sometimes call the general public comment, the speaker will come up to the podium and speak, and sometimes, if there's not any reaction from the legislative body, they might feel like they're not being heard. So I generally encourage the chair to kind of recognize what they've said and either, suggest maybe that staff will get back to them, or that the commission will take it into consideration. But you might also want to point out that under the Brown Act, you're not allowed to engage in a conversation or turn it into a discussion, because otherwise the members of the public might feel a little bit frustrated that, gosh, there's no response at all if they're just met with crickets. That's probably less of a concern for agendized items, for the public comment portion for those items that are on the agenda, because that usually is going to occur around the same time as the discussion or consideration of that agendized item. The Brown Act, while it prohibits a discussion of public comments for the general public comment, it does allow a brief response. So if a member of the public gets up during the general public comment portion of your meeting and says something that you feel is just, factually completely inaccurate and you really need to clarify the record, one member of the board or commission or a couple of board members can clarify that or provide clarity or correction if you want to. You're not required to, but brief responses or referring it to staff, that is allowed, just not a discussion. For special meetings, there's no general public comment allowed under the Brown Act. Now, some cities, even though it's not required under the Brown Act, they will still allow for general public comment, even for special and emergency meetings. But technically, under the Brown Act, we only have to provide public comment opportunity for those items that are actually on the agenda of the special meeting. So again, I mentioned that a meeting can sometimes occur inadvertently, even away from the dais, outside of City Hall. And especially in today's electronic age, this can happen if you are emailing a majority of a board or commission and they start engaging in conversation in that email, or if you text somebody and they have a majority of the commission is on that text thread. Once you start having a back and forth and a discussion, that is technically a meeting under the Brown Act, and it's not allowed because it's not on agenda. It's not part of an agendized meeting. So it's important to pay attention to those situations, especially electronically these days, where meetings can occur and they would be unlawful under the Brown Act. It could also happen on social media. So say you see a post on Facebook and members of the commission start commenting on it. That would be a discussion, and that's actually, I think it's in the slides, why the Brown Act prohibits a majority of elected members of legislative bodies from commenting on social media posts about subject matter, things that are within their subject matter jurisdiction. So as an example, say these folks are members of a commission, just a one-way communication between individual board members, that's okay under the Brown Act, because they're not trying to come to a decision. They're not creating what's called a collective concurrence under the Brown Act. So say in this second option, the first person and the second person talk to each other, then the second person goes and talks to a third person, and especially if they are sharing with that third person the conversation that they had with the first person, that's going to be a problem under the Brown Act, because that looks like they're trying to come to a decision, right? And they're not in an agendized setting, and so the public is not able to participate in that decision-making process. And it goes from bad to worse if you then include more and more members of the commission. That just looks like you're trying to make a decision outside of an agendized meeting. So what are some of the consequences of a violation of the Brown Act? Technically, under the Brown Act, either the DA or an interested party can send a notice to correct and cure, and if the legislative body does not do that, then they can go to court, and a court can reverse or nullify the decision of the legislative body. Members of the legislative body can be subject to criminal sanctions, and so it's a misdemeanor to willfully violate the Brown Act, so that should be noted. And oftentimes district attorneys will do investigations of alleged violations of the Brown Act, and they'll issue those reports. So even if they don't criminally charge a member of a legislative body, those reports are damaging to the legislative body, to the institution, and it breeds mistrust, so they're not good. In addition, the civil grand jury can investigate and issue reports of violations of the Brown Act. Oh, I should go back and mention closed sessions. So as I mentioned, the fundamental precept of the Brown Act is that we're going to hold meetings in public, we're going to notice them so the public can participate, and the public will be able to participate. The Brown Act does have some exceptions for what are called closed session, or sometimes folks refer to them as executive sessions. These are probably less common with our boards and commissions just because of the nature of the closed session exceptions under the statutes. But some examples that you might run into include potential litigation. So the Brown Act recognizes that there are times when a legislative body, for instance, the city council, needs to meet with the city attorney and talk about attorney-client privileged things, that communications that if the other side, the adversary, heard, that it would give the adversary an advantage over the city as an organization. And so the legislative body is allowed to discuss matters of potential litigation, either existing litigation or threats of litigation, in closed session with their counsel, their city council or city attorney. Sometimes that happens with boards and commissions. I've seen, for instance, planning commissions where there's a really controversial project coming before the planning commission. There are times when we've had conversations in closed session about the threat of litigation and how that might impact the planning commission's decision-making process. Other exceptions that are common, at least with the city council, are real property negotiations. So if the city is buying and selling property or leasing property and we don't want the other side to know kind of what the city is willing to pay for the property. Labor negotiations, in those cases, same thing when we're negotiating with our labor groups. We might not want them to know what the full authority that the council, what the legislative body has provided to its bargaining folks. Employment decisions, again, where personnel matters are involved. Those are some of the common closed session exceptions. Again, they're more frequently used by the city council, but I wanted to make you aware of them because sometimes you hear that reference and I want you to know kind of what that's about. So that's our open meeting law, the Brown Act. Its kind of corollary for public records is the California Public Records Act. And again, the idea here is to have transparency and to allow members of the public to participate in the governance of their community and to know what's going on. And in order to do that, the PRA allows us to gain access to a large number of records. We'll talk about some of the exceptions, but the general premise, again, is that records that are owned, used, or retained by a public agency should be available to the public so the public can see them. So this is actually enshrined in our California Constitution that every person has a right to inspect public records of any state or local agency. So what is a public record? A public record is defined very broadly as any writing containing information related to the conduct of the public's business that's owned, used, or retained by the public agency. And it's not just a piece of paper, kind of the traditional record that we think of. It's really anything that records in a tangible format any information. So it's audio recordings, it's video recordings, it's voicemails. It's anything that is tangible that can retain information. It's databases of electronic records. Those are all considered records. And if they're owned, used, or retained by the city, they're considered public records. And the presumption is that the public is entitled to either view it or get copies of it. So emails are considered public records, or at least they're considered records. If they pertain to city business, then they're going to be public records. So a few years ago, the California Supreme Court was asked whether emails that were sent and received by city council members on their personal devices, on their personal email accounts, but that had to do with city business, whether those were considered public records. And the Supreme Court said, yes, those were indeed public records. The fact that they were on the council members' personal phones or computers didn't matter. The fact that it was on their Gmail account rather than on their city email account, that didn't matter. The important fact was that they had to do with city business. The court basically said, look, if you analogize it to kind of a piece of paper, it doesn't matter whether that piece of paper is at City Hall or whether it's at home or in the council member's personal briefcase, that it's the subject of what the record is that is relevant. So that's why when you sign up to be a board or commissioner, we give you a city email account, and the city council's policy is that you use that city provided email account for city business. Don't use your Gmail accounts Don't use your personal email accounts, your AOLs, or whatever you have. Use the city-provided account. And we'll talk about kind of why that's important. The reason is because when members of the public then make requests, it makes it easier for the city clerk to go in through the IT department and access those emails. They don't have to then go to you and ask you to go search your private emails for all of the emails that you may have sent about your board or commission. Sometimes, inevitably members of the public might send you an email. Maybe you've known them for a while and they have your personal email account. That'll happen. What I usually recommend is to, if you can, reply using your city email account rather than the personal and say, hey, I'm replying on my city email account because this has to do with city business. Or at least when you reply, CC your city email account. That way it's on the city's server, and again, it'll make it easier for the city clerk to retrieve it if we ever get a PRA request for that type of information. Just going back to kind of some of the mechanics of a Public Records Act request. Before I do that, so again, the presumption is that if there's a record that is owned, used, or retained by the city, that it's a public record. Just like the Brown Act has some exceptions for open meetings, the Public Records Act has some exceptions for kind of institutional or sometimes privacy-related issues. So again, if there's a attorney-client privilege memo that is sent from the city attorney to the city staff members or city officials or you as boards or commissioners, that is exempt from disclosure under the Public Records Act. The law basically recognizes, look, the city doesn't lose its protection from kind of lawsuits just because it's a public agency. Sometimes there are personnel matters that have to do with city employees. Again, the Public Records Act doesn't allow members of the public to go and rifle through city employees' employment files just because they're city employees. They don't generally lose their privacy interests in their personnel files. There's also a catch-all exception where basically if the public agency can demonstrate the public interest in withholding a record or a portion of the record outweighs the public's interest in receiving that record, then the city can withhold that record or sometimes redact portions of the record. And again, it's usually dealing with privacy reasons or maybe safety reasons that catch-all is used. So, but again, the presumption is that it's a public record and the public is entitled to it, then there are some exceptions. So in terms of kind of the mechanics of how the Public Records Act works, member of the public wants to get a record, they can submit a Public Records Act request. You can do it online through the city's website. You could fill out a form and do it in hard copy if you want, but I think most of them are probably done electronically these days. Those go to the city clerk's office. And the city clerk's office reviews it, sees who within the city might have potentially responsive documents, sends the request to the various departments who might have responsive documents, sometimes to IT if they're searching for emails or text messages, and then gathers up all the potentially responsive documents. Then the city clerk's office reviews those documents to determine whether there are any exemptions that the city either needs to or can redact information, reviews it with the city attorney's office, and then provides the copy to the members of the public. Under the Public Records Act, the members of the public or the city can charge like a nominal copying charge for hard copies, and so the city, like most cities, charges that for photocopies. If the member of the public doesn't want to pay that, they can always come in and just see the copy and view it themselves. But they're entitled to copies if they want them and if they make copies. Anything you want to add about the PRA?
The PRA request forms are online, and you can have them to come by the office. You can have them to call us. I know there's some exception that says that, they don't have to fill out the form. So if someone calls, we'll take it over the phone or whatever, so we're trying to make that process as easy as we can. But those are getting to be, we get a lot of requests. So that's something that certainly that's on our primary list because we are getting increased amounts of PRAs, and they are requesting text messages, emails. So as Jeff said, please use your city email address, and hopefully you've all, have received those.
Brenda makes a very good point in terms of the volume. I would say in the 2.5 decades that I've been practicing, we've seen just a tremendous increase in the breadth of the requests that members of the public make. They will ask for all emails, to and from a particular public official, within the last 5 years. And that's, as you can imagine, that's a lot of records. And so, the city has a records destruction policy as allowed under law to kind of clean out emails and not have so much volume to have to dig through. But it's becoming more and more of an issue and really a cost to public agencies based on the breadth of requests. And we use a lot of emails and texts these days, and so that's definitely an issue. It probably bears noting, assume that what you write in an email or in a letter about city business is going to be public. I would encourage you to assume that it's going to be public, so don't put anything in an email or a text about city business that you wouldn't want printed on the front page of the local newspaper or posted on their website, because it may very well be requested and obtained through the Public Records Act. So be cautious. Wanted to raise an issue involving quasi-judicial hearings or public hearings. I think we included some material in the handouts about this. This is mostly for members of the Planning Commission and sometimes for the City Council when it makes its way up. Sometimes boards and actually also HSPB and ARC would often see quasi-judicial hearings. So the City Council, let's just use the City Council as an example, but it also kind of applies to Planning Commission, ARC, and HSPB. The City Council sometimes acts as a legislative body, a true legislative body, adopting an ordinance, adopting a law that is going to be prospective in its application. It's going to apply in the future. But then other times, a City Council or Planning Commission, ARC or HSPB is asked to look at an application for potential project and apply a set of facts, the project and its specifications, to an existing set of rules, the zoning ordinance, and see whether the project meets the requirements of the zoning ordinance. And we call that quasi-judicial. And the reason we call it is because you're kind of acting like a judge. You're acting to determine whether the facts of the application as presented meet the requirements of the law. And in those cases, you kind of have to treat yourself like a judge would. And that means not coming to the meeting with a predetermined decision that, I'm not going to ever approve any CUP for, name the project, gas stations. I'm never going to approve those. Well, if it's a CUP, that's a quasi-judicial decision. And just like we wouldn't want a judge coming into court saying, I'm never going to, rule in favor of a plaintiff, you as a planning commission or ARC or HSPB shouldn't have that mindset when you're coming into a quasi-judicial hearing. Instead, you should kind of keep an open mind. You should say, hey, I'm going to wait until I hear everything from the public hearing, hear all the evidence, hear from staff, hear from members of the public, hear from the applicant, and provide them that due process. This isn't the case when the City Council is acting in adopting an ordinance. If they want to adopt an ordinance and they dislike vacation rentals, they can harbor that position as a member of a legislative body who's acting in their legislative capacity. You can't when you're acting in a quasi-judicial capacity. So there's also a memo, I believe, in the materials about this. When you're going to have a quasi-judicial matter come before you, it's important not to go out and speak and to kind of take a public position on it before the public hearing. So there was a case some years ago where a planning commissioner, there was a project coming before them. They went out and they wrote in their HOA newsletter, how horrible the project was and how they opposed it. Well, when it got to the planning commission, that planning commissioner had to recuse themselves from participating because they had expressed a bias. They had expressed that they weren't willing to act like a judge in hearing the project application. So it's important for these types of matters to not get out in front of the public hearing process and take a position before the public hearing has closed at the meeting. So some examples of what might be a quasi-judicial matter: a conditional use permit is a quasi-judicial decision. A tentative track map is a quasi-judicial decision. Design review decisions are quasi-judicial decisions. Those are things where, again, you're being asked to determine whether a particular project meets a certain set of facts that exist under our zoning ordinance. Some examples of legislative decisions include, adoption of a zoning ordinance. So the Planning Commission makes recommendations to the City Council about whether or not to adopt a zoning ordinance or a general plan. Those are considered legislative matters, and those items you can harbor positions on things that are coming before you on a zoning matter or a general plan amendment, because those are just laws. Also on quasi-judicial matters, generally, a lot of folks say that members of the legislative body shouldn't be texting or emailing while at the meeting because it doesn't allow the public to really know kind of how a member of that legislative body is being influenced. But especially with quasi-judicial hearings, it's important to not be receiving information or evidence that the other side doesn't have access to. So kind of just like in a courtroom where you wouldn't want to have the judge receiving information from one side and not the other. In quasi-judicial decisions, we want to make sure that both parties have an opportunity to present their case, and that means being able to hear what the other side is saying. And so, if you've met with an applicant before the public hearing and they showed you the property or they told you about it, it's important to mention that during the public hearing, before you ask questions or provide your thoughts on the project. Say, hey, I met with the applicant a couple weeks ago, they showed me the project and this is what I saw. So that way, if the opponents of the project or if their supporters have something different to present, they can get up at the podium and they can present kind of their perspective on things. So that is kind of the rules of quasi-judicial decisions. So we've talked about the open meeting laws. We've talked about open records laws, the Public Records Act. The next set of laws are conflict of interest laws. So we have the Political Reform Act. This was adopted in 1974 after the Nixon scandal. And the general premise is that we shouldn't allow public officials to allow them to use their public position to obtain financial advantage. And another way of saying this is, as we'll see when we talk about recusals, is we shouldn't allow public officials to allow or even potentially allow their private interests to affect their public decision-making authority. When that happens, when their personal financial interests might affect their public decision-making authority, the law says you need to step back, recuse, and not participate in that public official decision-making process. In addition to the Political Reform Act, the city has adopted its own public integrity ordinance. And that requires disclosures of interests in rental property, which is not required under state law. And it also requires recusal and disclosure of fiduciary obligations that you might have to nonprofits. Again, that's not required under state law. There's a memo in the material that I've provided. Generally, under state law, conflicts are concerned primarily with your financial interests, and we'll talk about which ones in particular. Service on a nonprofit board is usually non-compensated, and so therefore, under state law, doesn't create a conflict of interest where a public official has to recuse where their nonprofit is involved. In Palm Springs, we've expanded on state law, and we've said, in some situations, if you serve on a nonprofit board, and that board either has an application before your commission or has a particular interest in a subject matter before your board or commission, then your position as a non-compensated nonprofit board member requires you to recuse from participating in making that governmental decision. So that's a little bit different than what other cities have, but we have it. There's also another law called Government Code Section 1090. It's technically not part of the Political Reform Act, but it's a doozy, and it's a felony, and it basically says that members of a legislative body, including all of yours, can't participate in making a contract between the city and some other entity if one of the members of that legislative body has a financial interest in that contract. It's a very old law, dates from the 1940s or maybe even earlier. It's not part of the 1974 Political Reform Act, but it's very broad in its application. Unless an exception in the statute can be found, it prevents the entire legislative body from participating in that contract. Usually the contracts are made or entered into by the city council, but some contracts are recommended by boards and commissions. So, the Planning Commission will sometimes recommend a statutory development agreement to the city council, and that qualifies as participating in making that contract. And so if one of the planning commissioners has an economic interest in, the developer or in the contract that's going to make its way maybe to city council, the entire planning commission might end up having to not participate in that decision because of this very old law. So keep that in mind. I know it's not mentioned here, but it's a big one. Probably less relevant for boards and commissioners than for city council, but it's still out there. So under the Political Reform Act, we've got two PRAs. We've got the Public Records Act and the Public Reform Act, so I sometimes slip up. But here we're talking about the Political Reform Act. So the general rule is that public officials, and that includes you, includes me and Brenda, we're public officials, we cannot make, participate in making, or attempt to influence a governmental decision in which we have a financial interest. The idea here is that if we have a financial interest in a decision as a public official, we might be tempted to make that public decision one way or another that benefits our financial interest. And so in order to avoid even the temptation of that, the Political Reform Act says we need to recuse. We need to disclose to the public and we need to then recuse, just let the rest of our legislative body take up the matter and step away and literally step out of the chambers is what they've said within the last few years. So that there's not even the appearance that we're trying to influence that governmental decision. So the Political Reform Act is, it's implemented and enforced by a state agency called the Fair Political Practices Commission, the FPPC. They adopt regulations that kind of implement it and give more specificity to the statutes. And they also investigate alleged violations and they enforce it by issuing administrative fines. The FPPC can also be enforced by the local district attorney as misdemeanors. So the questions are, is it reasonably foreseeable that this governmental decision will have a financial effect on your economic interest? And I'll identify which are the 5 economic interests we're talking about. Will that financial effect be material? And the FPPC regulations go into intimate detail about what is considered material. And you have in your packets some material about what the FPPC deems to be a material impact. And then is that financial impact or effect indistinguishable from the effect of on the public generally? This is kind of an exception that basically says, look, yes, you have a financial interest, and yes, the decision is going to impact your financial interest, but it would affect a large segment of the public as well. And so it's kind of hard to find anybody who could make this decision. So it allows you then to participate in making that decision. Again, if that impact or effect would be indistinguishable from the public generally. And then there are some other exceptions. You know, if a majority of your board also has conflicts so that you end up without a quorum and then your board is not able to even act, the Political Reform Act allows, through a random method of selection, to have enough folks requalified to participate so that you at least have a quorum to participate. So the Political Reform Act and our local ordinance, they have kind of two components. They have the disqualification component, where you have to disqualify from participating in making a decision if you have if it's likely to have a material impact on your financial interest. But these laws also have a disclosure component as well. And the disclosure component is really kind of to allow the public to serve as a watchdog. So we have Form 700s under the State Political Reform Act, and then we also have public integrity disclosure forms under our state or under our city ordinance. And these are public records where we, as public officials, disclose what our relevant economic interests are. We file them with the city clerk. They're public records. The public is then able to know, gosh, you know, I work for X company, and so then if X company ever has a decision in front of my board or commission, the public's able to say, hey, you should be recusing from this because I think it's going to have an impact on your financial interest. And so that's kind of how the two components of these laws work. And so disclosure categories, we have to disclose investments. We have to disclose interest in real property that's within or near the city of Palm Springs. There's an exception for your personal residence for privacy reasons. We don't have to disclose the address of our personal residence. If you have income, loans, or business positions, income of $500 or more, if the source of that income is located in or planning to do business within the city of Palm Springs. Sources of gifts, those are financial interests that we'll talk about. Those have to be disclosed if you've received gifts of $50 or more within the last year. And then travel payments. If you've received travel payments from any third party other than your employer, those need to be disclosed. Again, this is to allow the public to kind of keep an eye on us as public officials. We you know, city council, board members, city managers, city clerk, city attorney, most department heads, we all file these Form 700s and these public integrity disclosure forms every year. And you're given the Form 700s and the forms. They're required to be filled out within 30 days of assuming office, and then they're filed every year annually on April 1st. And for the city disclosure forms, it's semi-annually. And then you file a leaving office statement within 30 days after you leave a particular office. So if you haven't done that, city clerk and I would encourage you to do that quickly. So for conflicts of interest, this page is probably the most important page, in my opinion, that you should pay attention to. And the reason is because it's really up to you as a public official to know which of your financial interests might cause you to have to recuse. You know, I asked you what your day job is, but I, the city clerk, city staff, there's no way we can know all of the details about whether you have received income or gifts from people or what property holdings you have. Unless we look at your Form 700 every time the agenda is posted, we're not going to be able to identify these potential financial interests that could trigger disqualification. You all are in the best position to know whether you have these financial interests. So if there's one slide, and this is in the material that we've provided you as handouts as well. So the first type of financial interest you could have is a business entity in which you have an investment of $2,000 or more, or in which you're a director, officer, partner, trustee, employee, or manager. So say you have stock holdings in IBM. And IBM is proposing a project, a development project that's coming before the Planning Commission and ARC. In those cases, you have to decide whether the project is going to have a material impact on that business entity in which you have an investment. And the general rule under the Political Reform Act is for a business entity, if they're the applicant, then that's deemed a material impact on your business entity. When you have to recuse, that means you can't vote on the matter at the dais, but it also means that you shouldn't be attempting to influence the decision even before it gets to the dais. So you shouldn't be talking to staff and telling them what a great project it is or what a horrible project it is. You really probably shouldn't be talking to other board or commission members on your board or commission who are going to be reviewing it to try and influence their decision making. And that's, again, why it's important for you to know what your financial interests are, because you need to know, and you need to know early, right? You need to know before it comes to the dais that you have a particular financial interest in a decision that may not come before your board for 6 months, but if the applicant is coming to talk to you, or if a staff member is talking to you about it, you need to be recusing even from those early steps before it gets to the dais. So the second type of financial interest that you can have is a real property investment. So say you own property within the city or near the city. If it's an investment of $2,000 or more, then that's a financial interest. So say you own a home here in Palm Springs. If presumably it's more than $2,000, if that home is going to be materially impacted by a project, say the Arts Commission is going to approve the installation of art across the street from that home, that is likely to have a material impact on your home. And if that's the case, then the law says there's nothing wrong with that. It's not like you've done anything bad. In fact, it's kind of a good thing that you're involved in the city and you own property in the city or you have income in the city. But it just means you need to step away and not make the public decision, because the law assumes you might be tempted to make that decision in a way that impacts your financial interest. Another economic interest is what we call a source of income. So any person or entity from which you've received $500 or more in income within the prior 12 months is going to be considered a source of income. If your public decision is going to have a material impact on that source of income, then you need to recuse. So the quintessential example is your employer. So say your employer is Ralph's, and Ralph's is proposing a new project, and it's going to have to go through Planning Commission and ARC, might have to go to Public Arts. Ralph's, as your employer, presumably you receive more than $500, they are a source of income. And if they're going to be materially impacted, you need to recuse from participating in making that decision. And again, for sources of income, if they are the applicant, it's deemed material, if they're right before your board or commission. It's important to remember that this $500 or more, that dollar figure also includes community property interest. So California is a community property state. So 1/2 of your spouse's earnings are attributed to you in a community property state under the Political Reform Act. So that means that if your spouse received $1,000 in the last 12 months from their employer, then their employer is deemed a source of income to you, because half of that is attributed to you. So you need to kind of be cognizant of income to your spouse. This is probably one of the, most of these, as you can tell, are dealing with kind of financial interests. A lot of times people will ask, well, am I conflicted because my spouse has taken a position on the project? Generally, these conflict of interest laws don't really concern themselves with kind of personal relationships or friendship relationships. They're really more concerned with financial interests. And so this is one exception where you kind of do need to be kind of cognizant of family relationships. Yes, I have my first question. Thank you. I think there's an exemption for Well, I know there's an exemption for income received from governmental agencies. I tend to think of that as being like, salary from governmental entities. I've never really thought about whether Social Security is included. But the real question is, is the federal government ever going to be an applicant? I mean, I guess they could. They might be proposing a post office or something. I don't know off the top of my head if Social Security is included. I would assume it is, but again, I don't know if that source of income is ever going to be an applicant in front of us. Good question. Thank you. I would encourage questions.
Are sponsored tickets or events from nonprofits for non-city activities, do they count?
So the question was, are gifts of tickets or passes to nonprofit entities given by third parties income? They would probably be considered gifts under this next category, although there are a lot of exceptions under the FPPC regulations, and one of the exceptions is gifts of up to 2 tickets or passes to each public official from a 501c3 nonprofit organization for a fundraising event. So that's a good introduction to the fourth category, which is gifts. And I'll tell you, the Political Reform Act is very suspicious of gifts, and that's why it's considered an economic interest here. The Political Reform Act, it kind of assumes that gifts can easily be a disguised bribe. If you want to bribe a public official, just buy them Laker tickets, and they're gonna presumably favor you if they like the Lakers. And so there are a lot of regulations and rules about gifts, one of which is if you receive $630 or more in gifts from an individual within the 12 months before your governmental decision, then that source of gift, that person or entity is a source of gifts. And just kind of like your employer who gives you income, somebody who gives you that much gifts, the law kind of thinks you might be tempted to favor them one way or another. And so in that case, you need to recuse if the governmental decision is going to have a material impact on that source of gifts. So what is a gift, you might ask? Under the Political Reform Act, a gift is defined as anything that you receive for which you have not provided consideration. So somebody gives you $700 worth of Laker tickets, that's a $700 worth of gifts. Somebody gives you $700 worth of Laker tickets, but you write them a check for $400, that's $300 worth of gifts that you've received from that source of income. So that's what's considered a gift. Now, and the kind of diverging a little bit, the Political Reform Act has kind of 3 rules about gifts. One we've already talked about, which is the disclosure rule. If you receive $50 or more from a source within a calendar year, you need to disclose that on your Form 700. We're talking now about a disqualification rule, which is if a source of gifts of $630 or more within the last 12 months is going to be material impacted, then you need to recuse. So that's the second rule, a recusal. And then there's a flat-out prohibition against receiving gifts of more than $630 within a calendar year. So you might ask, well, how can I get $630 or more within the last 12 months if $630 or more is prohibited in a calendar year? The way it could work is, say somebody gives you $400 worth of Dodger tickets in November, and then in March of the next year, they give you another $400 worth of Padres tickets. You may ask, who is this person who gives Dodgers tickets and Padres tickets? Like, how can you like both teams? You have to decide once you've decided that. They have given you $800 worth of tickets within the last 12 months, but they haven't given you more than $630 in a calendar year. So that's just the 3 rules about gifts. The definition of gift is very broad, But then the statutes and the FPPC regulations have made a whole bunch of exceptions to to gifts that technically would be gifts, but that are so commonplace that the law kind of assumes they're not going to really influence your decision. So gifts from family members, you know, you're going to get birthday gifts or holiday gifts from family members, and so that's not going to generally disqualify you. You're not going to have to report those things generally on your Form 700s, and there's not going to be a flat-out prohibition. Gifts, inheritances, and devises, those aren't going to, I mean, even though they technically meet the definition of gift, they're not going to, they're so common and they're not likely to influence your decision as a public official, and so they're exempted from some of these. What I would advise you is if you receive something that you haven't paid for, assume it's a gift. If you want to talk to me or ask the FPPC for advice, please give me a call. My phone number, my contact information is here in the material. That's what I'm here for. That's my job. So please feel free to reach out to me. And that really goes for any of these categories. You know, if you ever have a question about whether you need to recuse from making a decision, please feel free to reach out to me. That's what my office does. We want to help you avoid getting in trouble with the law. And so ask, and ask early is what I say. Ask as soon as you see the agenda come out, or as soon as you hear about an application winding its way through the staff level. If you think you have a financial interest that may require you to recuse at some point, reach out to me, give me a call, send me an email, and we can go through it. The FPPC has a process where you can ask them for advice, and they'll actually give you advice. And if they give you advice and it's based on facts, then they can't later come and they tell you that it's okay to participate. They can't later come and enforce against you. And so yeah, ask me early, and because odds are if you ask me right at the dais and I don't have time to analyze the facts and carefully review it, I'll probably recommend that you just recuse in the interest of safety and in the interest of not violating the law. But if you tell me, you know, a few days or a week before it comes before you, that'll give me enough time to research it and look into FPPC advice letters and give you a good answer.
So you got two.
Yeah.
Under the gifts, the 630 per individual, let's say that one person.
Good question. So the question, if you're online and maybe didn't hear, is the $630 per person, or is there some sort of kind of aggregating? The law says that you look at individuals, but if there are facts that suggest that they are kind of cooperating, colluding, conspiring to put something together, then the law will treat them as an entity. So, you know, there have been situations certainly in the campaign contribution context where the FPPC does this, where, you know, a business entity that is applying for a permit or entitlement will tell its employees, contribute to candidate X or give tickets to candidate X to kind of curry favor. The law will treat that as one entity and not as individuals, for sure. Then were there some online?
She says, I work for a contractor for a government agency. Would this need to be disclosed or be an issue as a commissioner?
They work for what?
A government agency.
Oh, another government agency.
As a contractor for a government agency.
So if you're working in a private company that contracts with a public entity, then you would need to disclose the income received from that private company. If you are working directly for a public agency, there's actually an exemption from the definition of income under the Political Reform Act, and there's also an exemption under 1090 for income or salary received directly from a governmental entity. And I think the assumption there is, say you're a commissioner and you work for the County of Riverside, and so therefore you receive income from the County of Riverside. They're technically a source of income to you, but but the law kind of assumes, I think the law just kind of assumes that, you know, if the county were ever to come before your body, your legislative body, for a contract or something, the law makes an exception, whether it's true or not, that you as a governmental employee you're not going to want to curry favor with your governmental employee or employer. And so there's an exception from that. But if it's a private entity that just contracts with a public agency, that's definitely going to meet the definition of income. Okay, I think we've beat gifts to death. Personal finances. So this is actually just kind of a catch-all. So even if a decision isn't going to impact one of the other 4 categories, if a decision is still going to impact your personal finances, you know, your personal income, your expenses, your family expenses, your liabilities, as well as those of your immediate family, then you'll need to recuse. An example that I like to use for this is, you know, we have flood maps that sometimes get revised by the city council, or fire maps. Those can impact your homeowner's insurance, or even if you're able to get homeowner's insurance. And so that's considered a personal expense. And so that would be an example of a decision that might impact your personal finances. Again, usually we then have the exception for the public generally, because those types of decisions will impact a large segment of the city. And so it would probably fall under that public generally exception, but in the first instance, it would still qualify as a decision that impacts your personal finances. So memorize this slide. We talked about these filing deadlines. Anything you want to add, Brenda?
Yes, so in your packet, you should have gotten some information from us that kind of detail the 2 form. Jeff talked about the Form 700. The public integrity disclosure form is a separate filing. And I think people kind of think that they're the same, but they're not. NetFile is a company that we've contracted with online, so you're able to file that online, as well as the public integrity disclosure. You're able to file that online as well, but they are 2 separate forms, 2 separate filings. So I just wanted to underscore and highlight those for you, because they do seem and they do ask some of the same questions, but there is 2 separate filings that you need. If you've never filled it out and filed it, we'll need you to do it, for assuming office. Because I think our email may have said, hey, if you don't have any changes between this time and June, you don't have to fill it out. So I think, there may be some, mix up, or people are not understanding that you initially need to file it for assuming office. So all of you are pretty much new, or if you're coming on board, you'll need to file that initially. And then if you have any changes, you'll need to file it again. At the semi-annual period. So just kind of wanted to highlight those, but we do have that information in your packet that we sent you. And if you have any questions, give us a call.
Thanks. Couple of tips. If you're in doubt, err on the side of disclosure, and the same thing with recusal. As I mentioned, if I get asked about recusal kind of at the last minute, I'm generally going to err on the side of being safe rather than sorry. Here's the FPPC advice line. You're welcome to call them, or if you want assistance calling them, that's what my office is available for. We do have some kind of unique local provisions in terms of our public integrity ordinance. That is online if you're interested in going and reading it. One of the other unique provisions in our ordinance requires disclosure of rental property and disqualification if a decision is going to impact property that you rent from a landlord. That type of interest is generally doesn't create a conflict of interest under state law, but it does under local law. So pay attention if you rent an apartment for your residents, or if you rent property for your business, that is included under our local public integrity ordinance. We have some pretty strict rules about failing to file your mandatory local disclosure form, including being suspended or ultimately removed from your board or commission. So we've talked about the Open Meeting Law, the Brown Act. We've talked about the Public Records Act, and we've talked about conflicts of interest. The fourth category that we'd like to talk about is roles and expectations. And this is this isn't really something that's codified in law. This is really just more kind of like the heading says. These are roles and expectations. They're kind of norms that this city has, and that in my representation of other public agencies, most cities have with regard to their boards and commissions. The first point is that boards and commissions are advisory to the city council, with some exceptions. And, you know, you all are the eyes and ears of the city council. There are only 5 council members. We've got 45,000 residents here in the city. And so the city council has established these boards and commissions to kind of help the city council be a good city council, to hear from members of the public, from stakeholders, to specialize in different areas, whether it's art or development or human rights issues. So you can become the experts in this. You can really dig into these issues, but at the end of the day, you're advisory, primarily advisory. And the city council, they're the ones who are elected and make the policy decisions for the city. There are some exceptions. The Planning Commission is authorized to act on, you know, some entitlements on CUPs and tract maps and those types of things. But even the Planning Commission on other things like zoning ordinances in general plan amendments, they're making recommendations to the city council. And this is, you know, frustrating to some, but it's the nature of what boards and commissions are. They're advisory to the city council. And I think our city council has made some really good strides recently to try and engage with our boards and commissions and to communicate so that the commissions are kind of in line with what the city council is looking at as the ultimate policymakers. We've structured the boards and commissions to solicit additional community input and define programs and services. And again, I think that's something that the city council is interested in doing even more of. They've brought back the annual dinners with the boards and commissions. I think they've expressed an interest to really communicate more with the boards and commissions and make sure that the boards and commissions are in line with the council's goals as the policymaker. One of the roles and expectations that I think we see with the city council as well as boards and commissions is, you know, have a healthy and robust discussion and debate about issues. But once a decision is reached by your board or commission, you know, everybody should be rowing in the same direction. I think there's nothing, you know, we all have First Amendment rights, and there's nothing in the law that prohibits you from not doing this. But I think you'll find that your board and commission will work more harmoniously, and there'll be less strife if once the decision of the body is made, everybody starts rowing in the same direction, or at least you don't row in the opposite direction. Maybe take your oar out of the water, but don't row in the opposite direction. And have some patience. I mean, for better or for worse, our community likes to be engaged, and that means that the process sometimes doesn't happen quickly and can take a while. And so have patience during these processes. Personal opinions, again, this is something that there's no law that stops you from speaking your mind. But I think most boards and commissions have found that having individual board members out there kind of speaking on their own, unless they've been designated by your board or commission to be the spokesperson, it's better to let the designated spokesperson be the designated spokesperson. If you feel that you really want to say something or you need to say something that maybe isn't in line with the decision of your board or commission, make it clear. If you're speaking to the press or if you're speaking to members of the public, hey, this is my own personal opinion, blank. And make sure you're not representing it as the position of the entire board or commission. And then don't hesitate to ask for staff support. That's what staff is there for. Obviously, we don't want, a bunch of individual commissioners devoting a whole bunch of staff time to their own individual personal issues. But if the board or your commission is embarking on something, then it's entirely appropriate for that board or commission to ask staff to support them. And if staff feels like it's overreach or out of bounds, staff is always able to go to the city manager and start that conversation. But that's what staff is for. We have staff liaisons for every one of our commissions, so that's what staff's for. Do you want to talk about kind of what the agenda process looks like, kind of more nitty-gritty?
So the next slide pretty much talks about the agenda process. Staff normally creates or bring agenda items to our council agenda. They'll submit, but I do know that they are in conversations with our boards and commissions and, whatever recommendations that may be coming out of your committee. But ultimately, the staff would be bringing forth commission agenda items before council. Staff will submit reports for department review. The city manager approves those, and then they're sent to the city clerk's office to be placed on the agenda. The city clerk's office will assemble the staff report using our current agenda management system to format and publish the agenda, and respective reports and materials. We'll add those in there. City clerk's office distribute and post requirements. We're posting physically, as Jeff mentioned, and online. So before our city council meetings, you can find the agendas with the attachments online on our city website under, I think it's city clerk, and it'll say agendas, minutes, meetings. Any meeting you'd like to see is there with the videos as well as the attachments. So our city website is pretty up to date, and we're working on actually putting more historic information out there that you may have or question about or want to see. So right now, we are in the process of implementing a new totally electronic system called One Meeting, and we're hoping to go live by September 1. We're kind of hoping that this will actually streamline our process a little more as it relates to departments being able to submit agenda items electronically, instead of right now, the city clerk's office is manually putting in all of the information. So we're right on the crust of kind of going totally electronic. So hopefully that will streamline and make things more accessible so that you can retrieve and search information. We're working with Laserfish as well. So Laserfish will integrate with our new agenda management system. So you're able to search historic data if you need to. So that's kind of the agenda process.
Thanks, Brenda. I think we've covered everything. I'm trying to think if there's anything we didn't cover. I think that's about it. But again, we're here for questions. If you have questions about anything that came up. Yep. I appreciate that. This can sometimes be kind of a dry subject, so I appreciate you all staying awake and attentive and asking questions. I think my information, or my contact information as well as Brenda's is in the material. Please don't hesitate to ever give us a call if you have questions, follow-up questions. That is what we are here for. So thank you for participating. And if something comes up, if you think of something at 2 a.m., wait until the next morning, but feel free to give us a call, shoot us a text.
I want to mention too that we did provide on the shelf down there, you'll find a handbook for the City of Palm Springs boards and commissions. And it actually is very detailed as it relates to our form of government, our processes. It tells you about the Brown Act. It covers the oath, kind of what that looks like, and the requirements, your reporting requirements, how to be an effective member. It talks about parliamentarian procedures, how that works. So it's really a good guide for you if you have some time and you're bored and you want to do some reading. It's a really good item. And those folk online, we will provide the link to this document. It's our handbook. So hopefully you'll get a chance to kind of thumb through it.
All right, thank you very much.
Thanks for your time.